Hi, my name is Bruni, and today I'm going to present about international criminal law. Firstly, what is the role that law plays in society? A common response would be that law maintains order and peace. However, it is much more than that. The preservation of law and public order and creates another but not consistent role for law, the protection of civil liberties and human rights. Even in a democratic nation, limits can be enforced of freedom for individuals. There are certain views, for example, racist and homophobic views that go against democracy itself. In contrast, oppressive societies, governments, and lawmaking bodies take advantage of their role and completely destroy freedom for individuals. Fundamentally, there must be a balance. There is an ongoing debate about what extent to which law should safeguard public order as an alternative protecting freedom and rights. So what is actually international law? International law is a set of rules designed by a treaty or a custom and agreed between recognized nations, binding them legally. International criminal law is a part of public international law that settles individual criminal liability for international crimes. This body of law also seeks to bring wrongdoers to either international or national courts to be prosecuted by their crimes. International law is a relatively recent addition to international law. It was only after the end of the Second World War that it was accepted that international law could criminally prosecute individuals who have committed certain serious offenses. An example worth mentioning is the adoption of Roman Statute in 1998 to creating a permanent international criminal court. Currently, this is still a stage of development as new cases and problems arise every day, making the process a lot harder. At the current stage, unfortunately, international law still limits the responsibility of individuals for criminal acts. There are infinite ways of defining international crime. International law does not give a single definition or authority of what it is supposed to be. The only way to limit the concept of international crime is to reduce to what is usually called the Core Four. The Core Four is composed by genocide, crimes against humanity, war crimes, and aggression. Firstly, genocide is usually associated with Nazi Germany during 1933 to 1945, sadly associated given the large-scale destruction and discrimination of certain ethnic groups and races. The term genocide was invented by Raphael Lemkin to describe Nazis' attempt to wipe certain nationalities, ethnicities, and religious groups. However, genocide was not criminalized in the jurisdiction of Nuremberg International Military Tribunal. Lemkin advocated to include the genocide in the MIT, but the board decided to include the crimes against humanity category instead. Nonetheless, prosecutors and judges in Nuremberg ended up using the term genocide in the trials. Nowadays, genocide is obviously universally accepted as an international crime, whether committed in a time of peace or war. The United Nations in 1946 finally affirmed that genocide was an officially existing crime under the International Law Resolution 96, Section 1. This resolution clearly provides an evidence of opinion juries. Next up is war crimes. The law of war crimes is now a significant part of international criminal law, indeed. It is common to refer international criminal tribunals as war crime tribunals, even if they also have jurisdiction of their offenses. The list of war crimes in international criminal law and their complexity is reflected in Article 8 of International Criminal Court, statute which lists no less than 50 different war crimes. In interpreting and applying this law, we must pay careful attention to the law governing the conduct of warfare, what is now typically called the law of armed conflict. Some authors suggest that one of the great achievements of international criminal law is that it is now used to enforce the law of armed conflicts, and now those who violate it can expect to be held accountable before national and international courts. War crimes is such a big part of international criminal law that unfortunately the prosecution of war crimes is disappointingly rare and often frustrating complex. Also, not every violation of the law of armed conflicts is a crime. Correctly applying and interpreting the law of crime requires us to have some understanding of history and principles of law of armed conflict. Next up is aggression. All communities, whether international or national, suffer from the use of violence for their members to resolve one of their disputes. One of the tests of law when you face the situation is regulate the force by members. International law seeks to do this way in two ways. First, it stipulates the paramount obligation not to use force to settle disputes, which only limits to exceptions. Second, it has the disposal a procedure whereby international community itself may use force against those using violence. These are known respectively as the rules of unilateral use of force and rules of collective use security. Use of force by a state is said to be unilateral and occurs with the authorization of a competent international organizations, such as the Security Council of the United Nations. It is responsible, therefore, for use of force in this sense, though it involves more than one acting state. One example is NATO military action in Yugoslavia, Serbia, and Montenegro during the Kosovo crisis in 1998. Mentioning the United States, what is the purposes? Article 1 says that it's to maintain international peace and security and to take effective collective measures to the prevention and removal of threats to the peace and to the suppression of acts of aggression and other breaches of peace, and to bring out peaceful means in conformity with the principles of justice, international law. Adjustment or settlement of international disputes or situations might lead to the breach of peace. Furthermore, Article 2 states that all members shall settle the international dispute by peaceful means in such a manner that international peace and security and justice are not endangered. All members shall refrain in their international relations from a threat or use force against the territorial integrity and political independence of any state or other element consistent with the purpose of the United Nations. Finally, we have crimes against humanity. The first prosecution for crimes against humanity occurred before the Nuremberg International Military Tribunal, the MIT, in 1945 to 46. Under Article 6 of London Charter, Nuremberg MIT had jurisdiction over the crimes against humanity. An obvious inspiration for including such a crime in Charter used to the term crimes against civilization and humanity in 1915 Joint Declaration of France, Great Britain, and Russia in condemning the massacre of Armenians in Turkey during the First World War. Following the First World War, the Allies established a 15-member panel. The Commission recommended that there would be trial for both war crimes and crimes against humanity. However, at the time of the U.S. took the view that crimes against humanity was too vague and resorted to a concept of found criminal prosecutions, and no such prosecutions were occurred. In 1915 Joint Declaration, thus a weak historical precedent, the Allies had two concerns: the need for an offense that covered crimes against civilian population in Germany, such crimes committed in occupied territories would be war crimes, and creating a link between crimes against humanity and the war-related offenses, either war crimes or aggression. In the MIT Charter, the link between other offenses was seen as necessary for at least two reasons. First, the international law had previously placed a few limitations on what states could do their own nationals. Thus, this exercised international jurisdiction over acts committed by Germans against other Germans was considered an extraordinary invasion and considerably excursion state sovereignty. The war link helped the scoped crimes against humanity situations where the offenses had some impact on other states and therefore international dimension. Second, the concerns of this novel crime being retrospectively applied may also help explain to desire to link crimes against humanity with the clearly established category of war crimes.